All right, everyone. Good morning, good morning, good morning. It is Friday, October 28th, and we are blessed to be here in the presence of Allan Rouben, who is going to be speaking to us about professional negligence. But before we begin, the normal caveats apply. First off, just a recap, our group is now approaching 11,000, so that's really awesome. Thank you to everyone who continues to make it a vibrant place. And those of you who have been part of our group for a while know what comes next in my little spiel, which is that while our group is private, our videos are public. And so anything that is said on this session is going to be displayed on any number of fora. And as a result, please be aware that this is in fact public. I don't really have any other group administrative stuff to talk about, but as I do have 4 minutes before Allan speaks, I want to actually preface what we're going to actually listen to. In an upward market, everyone makes money. And as a result, one of the features of an upward market is that mistakes are covered up. What I mean by that is that even if someone has gotten their clients into a bad situation, clients are less likely to sue. Rather, they're just likely to ultimately sell and perhaps even benefit because their property is worth more than what they purchased it for. Upward markets have a way of covering for discontent and incompetence. Downward markets are the polar opposite of that. In a downward market, any mistake that is made is looked to, and people will ultimately find that there are people that they can point to in such events. I'll give you an example of one that happened to me yesterday. Yesterday, a client went ahead, presented themselves to my office. They had agreed to purchase a property. They did not forward the deposit. And they subsequently, the property resold at a loss of several $100,000. They turned to me and they said, "Is there anything we can do?" I said, "Likely not, because we all know the law. And if you don't know the law, then you should speak to Sandy and she'll inform you of what the law is in this respect." But fortunately, there were both counsel and a realtor who put in writing that failure to pay a deposit meant that the agreement itself did not consummate, something that was very wrong in law. And accordingly, these people now have a professional claim as against their lawyer and as against their realtor. This is the order of the day, and we're going to be seeing this more and more. To that end, it is my pleasure to introduce Allan Rouben. You know, it's all well and good to listen to blowhards like me comment on what it is I think based on my recollection of law school of 20 years ago. It is an entirely different thing to hear litigators who practice in this field and are shaped by the experience of going through professional negligence claims. And that's why I mentioned at the beginning of this, we are blessed to hear today Allan Rouben. Allan is someone who has deep experience in this field, and though his experience does not limit itself to professional negligence claims, it is part and parcel of his bevy of skills and the things that he has experienced in court. So again, in an effort to make your time purposeful, I'm going to turn this over to Allan. Allan, I'd encourage you to speak about whatever it is you like, and then we'll open it up to a back and forth as agents have questions, I am sure. And no doubt everyone who is here will never experience or need Allan's services. The reason you're doing this is to better yourself. But in the event you do, there's no one better out there in the field. Allan, I'm turning it over to you.
Thanks very much, Mark, and thank you so much for the invitation and to all your participants and listeners today. I thought I would talk briefly and give a few examples of the duties of agents, which I'm sure everyone here is well familiar with, but how courts have treated those. So in one early case from 1987, a couple wanted to invest some funds that they had earned from the sale of a cheese shop. And they hired a realtor to look for an income producing asset for them. And they settled on the condominium building in Meaford. This was in the mid 80s. And the agent, in looking over the potential purchase, prepared a cash flow statement for them that assured the buyer that the expenses would be covered from the rentals. And this turned out to be seriously mistaken, and the agent had not had overestimated the rents that could be obtained. Apparently, in those days, nobody in Meaford knew anything about condominiums, and so they were difficult to rent. And the agent had also underestimated the expenses. So an action was brought against the realtor, and this is what the court allowed the action, and referred during the course of the proceeding to a statement from an earlier case in Alberta, where the judge said the position of real estate agents in showing properties to prospective purchasers is difficult, to say the least, in that they are the agent of the vendor from whom they will earn their commission, and as such are anxious to conclude a sale. They know or ought to know that most information sought by a potential purchaser on such occasions is relevant to the purchaser and will be relied on by the purchaser in making a decision whether or not to purchase the property. I'm satisfied that a competent real estate agent has that basic understanding, and therefore the standard of care required of such an agent in performing his duty to a potential purchaser is to be not only honest in expressing an opinion, but also to have some valid factual basis for any opinion expressed. If the agent has no valid factual basis for expressing an opinion, then the agent ought to state that fact or qualify the opinion expressed so that the purchaser knows what reliance can be given to the opinion, or at least be warned not to rely solely on it. In a later case arising in the township of Thomasburg, a young couple, first-time buyers, were purchasing a property, and they went through it and ended up purchasing it without a home inspection. And after they moved in, they noticed that there was severe sloping in the kitchen and bedroom floors, and later discovered that one of the basement foundation walls was cracked. And when one of the foundation walls failed, the township ultimately declared the property to be uninhabitable. And the township itself was found negligent in failing to properly inspect the property. But in respect of the real estate agent, the senior judge in Ottawa had this to say: she was the plaintiff's agent, and in that capacity owed to Ms. Wood a standard of reasonable care and competence and a fiduciary obligation, both of which she failed to discharge. In particular, she made no inquiry about defects in the home and failed to notice the readily observable floor slope on the inspection visit. When the floor slope was discussed at the time when the offers were presented, she failed to advise her clients of the existence and potential significance of this defect in the house. She failed to recommend a building inspection and the inclusion in the offer or in the signed back offer of an inspection condition. She failed to advise Ms. Wood that the vendors had preferred their offer over a full price offer, in part at least because they were not requiring an inspection. I find that Ms. Barlow wished this deal to be completed for her own financial benefit and was prepared to have her clients, unsophisticated first-time home buyers, take the risk of purchasing a potentially defective house. She let her clients down badly. In 2011, an important decision came out from our Court of Appeal. That's the highest court in the province. And the seller in that case had filled out a seller property information statement. It said that there was had been some settlement in the house, but no further problems for 17 years. And this did not fully describe the foundation issues, and the information sheet also didn't accurately described the plumbing issues with the house. And the trial judge found against the sellers in that case based on negligent misrepresentation, but he dismissed the action against the agents on the basis that they had reasonably relied on the information from the seller. And the Court of Appeal overturned that decision. And here's what they had to say. In my view, Ms. Waddell had plenty of reasons to question the veracity of the Sherback's assurances that the settlement problems had long since been resolved. She was a real estate agent with 33 years experience specializing in residential houses. She knew that the house had a history of settlement problems and accordingly was underpriced. As well, her visual inspection of the property disclosed settlement problems, the manifestation of which was sufficiently significant that it prompted her to further question the Sherbacks. Against this background and Ms. Waddell's admission that she was no home inspector, it seems to me that she had good reason to look behind the Sherbacks' representations. And the court relied on the Code of Ethics, which state a provision which states a licensee shall encourage the parties to a transaction to seek out appropriate professional advice when appropriate. So those decisions, as you can see, set the framework and the standard. And as was once famously said about the Soviet Union, trust but verify. And of course, there's the Code of Ethics under the Real Estate and Business Brokers Act provisions which state that a registrant shall treat every person the registrant deals with in the course of a trade in real estate fairly, honestly, and with integrity. And further, a registrant shall promote and protect the best interests of the registrant's clients. Both of those provisions import fiduciary obligations of honesty and good faith in the relationship that agents have with their clients. So we're here to consider professional obligations in a declining market. And I think it's fair to say, human nature being what it is, that we can expect parties to failed transactions to look to others with deeper pockets to blame. And in these circumstances, particularly, it seems to me that it's a good idea to practice defensively. Document communications in writing. Get written acknowledgement and confirmation of instructions. If things go wrong, the client will undoubtedly say that they relied on their agent. So in my view, there's nothing wrong with maintaining professional distance from the client and adopting a business-like approach to the relationship. As lawyers know all too well, your client is not necessarily your friend. In my case, I make it a habit to, in initial meetings with clients, to give them a bit of a cold shower and point out flaws in their case with a view to managing expectations. And it seems to me that in all sorts of professional relationships, managing expectations is a good idea. And let me conclude by just saying a few words about limitation periods and damages. The Limitations Act from 2002 sets up a basic limitation period of 2 years from the date on which the claimant had discovered their claim. So there can be complications about when a claim was discovered, but if you or any of your clients have potential claims, please keep in mind that there are time limits to pursuing those. And finally, with regard to damages, when someone is wronged, they're very anxious to get justice, and they want to proceed and move forward and get their day in court. But once they go through the meat grinder of litigation and the cost and delays that can be associated with that, their views can change quickly. And so it's best to, at the outset, take a very realistic look at what are the damages, and what can realistically be proven. And here again, it's best to manage a client's expectations with regard to potential damages, because unless they're fairly significant, it may not be worth the headaches and aggravations of litigation to go forward and to go forward with a court action. I just leave that with you to think about when you're contemplating, or any of your clients are contemplating bringing a claim.
That's true. That's terrific so far, Alan. That's very, 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 very helpful. May I add one quick thing, if you don't mind?
Sure.
Particularly for the new agents on this session, I just want to recap one thing Alan mentioned, and he was doing it in the reading of the case law, where the courts themselves affirm that in the event that someone doesn't know something, their job is to state and qualify any of their opinions, and to state that, you know, they do not know what they do not know. At the same time, we have to combine that with what Alan was saying in the lateral part of what he was mentioning, which is that, you know, this is a professional relationship and that they will point fingers at you. Realtors are in a bit of a bind, because at the heart of a realtor relationship is a good-natured relationship. It isn't necessarily adversarial the way it is with a lawyer, where you desperately need someone, you just take the best person who's the most aggressive person in some instances. With realtors, you're constantly befriending someone, trying to make them at ease, and yet at the same time, you have a range of professional obligations. What I say to young lawyers, particularly those in the field, is that it is critically important that you document your interactions with people. There are two different ways you can document those interactions. The first is to say, "Dear sir, pursuant to our recent time when we went out to see, you know, 185 Legion Road, and you mentioned to me X, I therefore told you Y." That's not going to further your relationship. The key to being a good agent, to maintaining good relations, but at the same time, protecting yourself professionally, is learning, specifically when you're young, how to write cover your ass letters that don't appear as such. So you're able, as an example, to sit, cover your ass, excuse me, cover your rear. I forgot we're being recorded. I'm sorry, Alan. I'll soap in the mouth shortly. But you can cover your rear if someone says, "Oh, the school's district isn't important to me." Instead of saying, "Dear sir, pursuant to our conversation, schools districts aren't important to you," you may want to say, "Hey, you know, Judith, it's been a real pleasure taking you out. I really enjoyed it. I'm so glad to hear schools aren't important to you. You know, that really opens up the field of, we can see this building, this building, this building." You can get the information into email form whilst still, and thereby protecting yourself while still maintaining relationships, and ultimately crafting something that is protective and yet at the same time not abrasive. That is a critical component, because what we need to learn how to do is protect ourselves while ultimately getting our deals.
That's an outstanding point, and very, very well said, Mark. It's all well and good, you know, for me as a litigation lawyer to maintain a professional distance from my clients. I agree with you wholeheartedly that an agent is in a different sort of position with their client, in, you know, working collaboratively. But having said that, we still have these professional obligations. And so there is nothing wrong with documenting your communications in that soft manner that you just said. And I think you put it very well.
So, Alan, are you okay if I open up the floor? I have a whole range of questions, but I have a feeling that other people are going to also have questions. Are you okay if we open up the floor to some questions first for you, as people kind of go through what they're wrestling with. Obviously, nothing specific, just general questions about the law.
Sure, absolutely.
Terrific. So guys, if you have a question, feel free to raise your hand or unmute yourself and feel free to ask. If not, I'll start asking questions.
One thing that I would like to have covered in the group, especially for buyer agents, is in our legal group, we see an awful lot of buyer agents. When there's a problem, they're encouraging their client, oh, you can sue. And they don't understand that if it's their responsibility, they are the one that will get sued, not the seller and not the listing agent. It's actually on the buyer agent. And they're encouraging lawsuits without understanding that it will go against them themselves.
Now, Alan, maybe you can speak to what happens when a suit is actually launched and who is involved and why. So if fundamentally, say, there is a buyer action, who would normally be sued? What is who would talk to us about the complaints process and how that normally plays out, just in a general sense?
Sure. Well, if a buyer is suing a seller, refuses to close a transaction, then a buyer will commence a claim under the contract against the seller. They might they might bring a claim for specific performance, try and get a certificate of pending litigation, and if there's grounds to make a complaint within a claim against any of the agents, then they might add them in the claim. But what is more likely to happen in a scenario like that is that a seller says, oh, well, I was misrepresented in some form or fashion by my agent, and then they bring what's called a third party claim against the agent, which is technically a separate proceeding, but it's underneath the initial claim and is generally heard at the same time. So the seller is essentially trying to fob off any responsibility that they might have to a buyer onto the agent and essentially flow through any damages that might be awarded. So that's, in very general terms, that's how it normally works out. And that's why I said, sometimes things get complicated, and the more parties are added, the more complicated it gets. And it turns into a bit of a meat grinder, as I said.
In your professional experience, and maybe this is a bit of an unfair question, what is is there any claim that you see over and over and over again levied against real estate agents?
Well, like with some of the examples that we just looked at, it's essentially going to be based on misrepresentation of facts, to lead someone to do something that they wouldn't otherwise have done. I think with the rising market that we had seen earlier, what we're likely to start seeing now are claims where clients were being told to make investments that weren't necessarily suitable for their circumstances, and were promised certain things about the ability to resell and make profits, and that turns out not to be the case. So, I think in those circumstances, you're going to see claims for negligent or fraudulent misrepresentation.
And you see that frequently, the misrepresentation claims.
I'm seeing that now for sure. Yeah.
So just to remind everyone here, a misrepresentation is a statement of fact, not opinion. You remember down at your REA courses or Sheridan courses that there's a significant difference between saying, I think a pool would look lovely here, and you can put in a pool, right? Like there is a significant difference between those statements. And if in fact you're making statement of facts as agents, you have an obligation to make sure that those statements are accurate if they are being relied on for the purposes of the contract. If you make a statement of fact after the contract has been consummated, no one has relied on it. Whereas if you are making it and it is therefore integral to someone deciding to move forward, then that misstatement of fact could be a misrepresentation. Those misrepresentations, I'm sorry, Alan, I'm just education here, to take three forms. One is innocent, negligent, and fraudulent. Fraudulent requires intent. And of course, the thing about fraudulent claims, if you get them, is that they survive bankruptcy, which is nice. Negligence is the one that most people like Alan will always aspire for because it requires a lower burden of proof and thus is easier to claim. And innocent is when there really was no knowledge, and it was said with if someone sent their kids to a school and therefore said, yes, it's in this school district, and the school district unknowingly changed a month before the sale, that would be an innocent misrepresentation as opposed to negligent, but because there's grounds and reasons for it. Is that a fair encapsulation, Alan?
Yeah, absolutely. And, you know, there's no point alleging that someone made fraudulent misrepresentations unless you have very strong proof of that. But you don't need to prove fraudulent misrepresentations in the normal course of things, as we've seen in some of these examples.
Right, negligence ultimately gets you into the pockets of the insurance, and because it has that lower standard of proof, almost every lawyer will opt for negligence over fraudulent every time, even if there may be fraudulent activity.
That's right.
Fair enough. All right, next question, guys. If not, I'm going to speak, so please feel free. Anyone who has a question about negligence. No? Okay. So, Alan, in terms of this whole field, there is the propensity of agents, because they're the front of process. By which I mean, you and I are familiar as lawyers being the back of process. What that means is almost every file that comes to us gets referred by another professional, right? That's the travails of being a lawyer. Real estate agents, even if they don't realize it, have tremendous power because they're the front of process, meaning that they can then say, okay, now that we've done this, let me recommend you to my lawyer. Let me recommend you to my mortgage broker and everything else. What liability exists in the recommendation process if the recommended professional that has been given to them or to the client by the real estate agent turns out to be a less than reputable individual or ultimately gives negligent advice?
Well, I think unless the agent has reason to believe that the professional that they're referring to is incompetent or unable to fulfill the job, I don't think that they should be held responsible for the actions of another professional. Sometimes, you know, if they're steering someone to another professional and getting some sort of kickback out of it without regard to the merits of that other professional, then I think that could be problematic. But in the normal course of things, referring someone to another professional is, you know, I would think absolves them from any further responsibility thereafter.
Okay. I'm going to have another question in a second. I'm just going to open it up again. Does anyone have any other questions right now? Yeah, we have a question. So Jagmeet wrote me directly, so no one else can see it, but it says, is it negligent that you didn't advise a seller in writing about the tenant leaving if it was discussed verbally, and now the deal falls through because the tenant didn't leave? So let me be very clear. Alan, I'm not sure if you're familiar with this or if you've had a case yet, but it used to be so right now, under a normal agreement of purchase and sale, vacant possession is required pursuant to Section 2, absent anything else in Schedule A. Having said that, the law and the reality are two very different things. At the present time, even if an agreement calls for vacant possession, and even if a seller goes ahead and states that they will provide the notice to vacate, the courts being backed up the way they are means that tenants practically often do not vacate in accordance with their legal obligations, necessitating a landlord and tenant tribunal action that can take upwards of a year to resolve. Agents are aware of that. What happens if you did everything correct in writing? That is to say, you put into Schedule A that there are tenants, that that the seller shall go ahead and provide notice, and the seller goes ahead and provides notice, but the tenant does not leave. And if you're acting as the buyer's agent, you, aware of the general state of what's going on out there in the industry, did not advise your client that that was a possibility, even though everyone has acted legally correctly. Is there negligence on your part? That's a very interesting question by Jagmeet.
Wow, that is an interesting question. What would have been done any differently, though? That's the thing. Like, what could have been done differently?
So what happens now is agents in the field are now crafting clauses in Schedule A that account for that say notices to be provided. And in the event that the tenant fails to leave, this is the professional standard that is now being adopted. And in the event that the agent fails to leave, then X. Then the price shall be abated by 50,000. Then the agreement shall not consummate. That is now the new standard that other people are adopting. Not everyone, it's not even part of our forms yet, but many people who deal with this regularly, that is a professional standard of competence that many people are bringing to the table.
Well, if it has seeped into the profession to the point where it's becoming, a professional standard of care, because this is happening frequently enough, then it can become part of the standard of care to suggest or recommend that that sort of clause go into an agreement. So that's why, in these, when you have claims against agents or any other professional, the courts expect to see both parties put forward expert evidence on the standard of care. Unless the breach is so apparent on its face, you're going to need evidence from a professional realtor who can give an opinion that this conduct failed to meet the standard of care. And in some cases, there could be very difficult questions on what exactly that standard is. So the circumstance that you're talking about now, I think it would, if it ever came to a court action, would undoubtedly result in competing expert evidence on what exactly was the standard of care. And not only what the standard of care is, but did it cause anything? What was the cause of the outcome here?
It's really fascinating to be speaking about this particular point of law, because I don't know if people, most people here haven't taken constitutional law, but the fundamental difference between, beyond a whole bunch of other technical details, the fundamental difference between the interpretation of the Canadian Constitution and laws and the American Constitution and laws is that there is a movement in the States to actually have what's called originalist construct, meaning that you are trying to interpret what the drafters meant at the time that the Constitution itself was drafted. Whereas the Canadian construct about law generally and our Constitution generally is that of a living tree. That is to say, things develop and we need to account for that development in our laws. And what we're talking about here is something that has arisen largely as a result of COVID and the backing up of the courts, creating a new fact on the ground and thus creating new professional standards that, while not recognized yet in court, because I can assure you it hasn't yet worked its way through the court system, or it doesn't, I don't think it has at least, it doesn't mean that we don't need to be on guard as agents, understanding what best practice is, because we're going to be held to that best practice in order when a professional negligence claim is actually made. Is that a fair analysis?
Yeah, it is. Best practice, though, might be, the standard of care might be a little lower than best practice. So I just throw that out to you as, as a possibility. And that if a claim like this were to find its way to court, that that would be the argument on the defense side of things for sure.
Great. I have a really interesting question here from Stephen, which is way better than his first question. Is this going to be recorded? His new question is, and we're going to forgive him for that one. For properties listed on a sold as is basis, if the buyer is advertised, and if it is advertised as such, would any of the buyer's agent's obligations be accordingly reduced? So if a buyer goes ahead, says this property is as is, advertises it as is, and then induces an offer that contains an as is clause, does that therefore reduce the buyer's liability? Buyer's agent liability, buyer's agent liability.
I would think so. You know, as we saw in some of these decisions, there's obligations to verify on the agents. But the contract still governs, you know, to a large extent. And so a buyer or a seller in that case is going to have to get out from underneath the wording of the contract. As is, though, remember that if you're aware as a seller or an agent of hidden defects that are, you know, serious problems, then there may be obligations to disclose that.
So it doesn't affect the disclosure obligations of the agent. It merely affects the ability to claim that anything retroactively about the property that was not known by the seller. That is significant.
Yeah, I think so. And, you know, the whole subject of caveat emptor and hidden defects or latent defects and obligations to disclose, you know, there's varying case law on that. And the circumstances, you know, in individual cases are very important. So you can't necessarily make blanket statements on it. But I think in general terms, if you have an as-is conditional clause, then that would tend to reduce the need to verify certain things that might otherwise be the case.
Okay. Thank you for that. Thank you for the question, Stephen. Anyone else, guys? Any other questions right now? Feel free to unmute yourself if you like and ask.
I know from a buyer's agent's point of view, if I saw a property that was advertised as is, that would put my antenna up more rather than feeling that I have less responsibility. I would feel that I actually have more responsibility. I regard it as a warning. So I'm going to dig even deeper on the property for my client.
Yeah, I think that that's a good point. But, you know, then that's certainly a best practice. That might end up putting you into conflict with your client. You know, if you turn up things that they may not want to disclose, but then, you know, if something has to be disclosed, then it's best that they hear it from their agent.
Sorry, I meant as a buyer agent, not as the seller's agent.
Oh, yeah.
I don't feel that as-is clause relieves me of responsibility. I believe that it actually imposes more.
Well, yes, for sure. And you're going to be, you know, you're going to be advising your client that, you know, they're taking a big risk by purchasing something with that condition in it. So from, you know, from your perspective, you can dig around, that would be appropriate. But at the same time, you would probably be, you know, preventing a claim against yourself by documenting in writing that you have informed the client of what they are giving up by signing a contract with these conditions. So, yeah, I think that would be relieving you from any potential liability.
On the same vein, you're familiar with our Form 127? the get out of jail form that we say we have the buyer sign saying, you know, you realize that you're not including a financing condition, you realize that you're not including a home inspection, and you assume all risks. Have you ever seen any case where the court didn't accept that? It's not a get out of jail free card for the buyer's agent. They still have an obligation to go further than just having that form signed?
Personally, I haven't seen cases where that was disregarded, but that doesn't mean it wouldn't be. Like, you know, just because someone signs a form, the client might well say that, oh, well, the agent told me that this was just routine and, you know, it wasn't a big deal. And if they had told me that I should, you know, get a home inspection, then I would have done it. You know, there's lots of ways for clients to try and walk away from what they signed in that regard, in the same way that, you know, people all the time try and qualify contractual language and say that it doesn't apply. So it's certainly good practice to have those things signed. And in the vast majority of cases, I think they would hold up. But going back to human nature being what it is, you know, some clients are going to say they didn't understand it or were told differently, you know, by the agent in one form or fashion or another.
Can I ask you, this is Gabriela, related to this, in case if we make a note where a communication regarding these waiving conditions that the client understands, that would actually a supporting document in our case if in any ways we being taken and later on the client says, no, I haven't been informed. Am I right or wrong?
Well, yeah, absolutely. And it goes back to what Mark was saying earlier in terms of documenting your communications with, you know, softly worded emails and things like that. If someone, you know, has acknowledged something, there's nothing wrong with confirming it in writing in such a way that it's, you know, not looking like you're necessarily covering your back end. So yeah, I completely agree with you.
I'd like to just point out that there's a big difference between what was, you know, the 1980s note to file, which is a lawyer writing into a file and making a note and signing it, and communicating your note to the other side, because the communication of a note via email is documented evidence that you're not trying to defend yourself at the time of a suit. It is, thank you very much, at the time this was done. I'm not manufacturing a note now to make myself look good. Here's the communication that was taking place. The court is going to try to discern whether or not that information was properly conveyed. So the email, the facility of email in covering our rears is a magnificent one. It should be noted that it's not a note. I don't know if you just used that term inappropriately or what you were talking about, Gabriella, but it's not just a note. You really want to email. It stands as better proof for the court. It really does.
Yes, this was my second question. That does this necessarily have to be in an email form or an actual text message or
No, it's fine as long as it's been
WhatsApp
communicated. Text form. I'm sorry, Alan. I'm just going to steal your thunder on this answer. As long as you can prove that it has been communicated, whether it's text or email or anything else, it all has the same effect. The only difference is the text messages over time get erased. That isn't to say that they're intentionally erased, but your phone number gets changed. You lose your phone. Something happens. It was done on a WhatsApp. Like passwords are lost. Email is better because it usually has longer duration and longevity. But having said that, assuming your texts are there, that's perfectly admissible. There's no issue.
The only thing that I have as Form 127 versus just an email saying, you know, I recommend that you have a home inspection is at the bottom of Form 127, the buyer specifically acknowledges and accepts the risk involved. And that's the language that I want to see.
Yeah, that's a good point. Let me just pick up on this discussion, though, about the importance of documenting, you know, and confirming things with your client. If it's left to, and this applies to lawyers specifically, where courts have said this, and doctors as well. If things are left where one party is saying one thing happened at the time, and the other party is saying that something different happened at the time, and it's an important fact in the litigation, and neither side has documented anything at the time, then the court is left with competing versions on the one side from the professional and on the other side from the client. And when faced with those circumstances, courts have often said, and you may not like it, but this is the view they take of the matter, is that the client's information is more likely to be true. Why? Because this is one matter to them. This is an important life event for them. Whereas for the professional, it's one of hundreds of matters, similar matters that they are dealing with and have dealt with since this event took place. So it's not that anyone is misrepresenting the fact of what they're saying in court or being untruthful. It's just that they are misremembering something, and the courts will say that it's more likely that the professional will misremember something because they've dealt with hundreds of other matters in the meantime, and it didn't have the same significance to them as it did to the client. So the client has more reason to remember accurately what happened. And I think there's some truth to that.
Interesting. That's actually very interesting. So guys, be on your guard. Alan, I hope you don't mind me. I'm going to ask you an unfair question, but it's one that bothers me. I don't have an answer to this. And if you don't have an answer to this, I think it's just best. We'll just say we don't have an answer and that's it. Why are realtors always subject to a lawsuit? And why do lawyers so rarely go after mortgage brokers? I'm asking this because in my history, and this is based only on my personal experience, I always see mortgage financing being a fundamental component of a reason a buyer can't close. And yet, I rarely see mortgage brokers being faced with lawsuits, despite them being insured individuals. Is there, maybe there is no answer to this, I don't know, but do you have an answer to that? Do you know what's going on there?
What would you say would be the grounds for a claim in the typical case against the mortgage broker?
The vast majority of times that I see mortgage brokers screwing up are where they submit things very, very late in the day. Let's deal with that, which is, by the way, hidden from the public. The public doesn't get to see when these submissions take place. But oftentimes, if you really delve into it, you find out that they've submitted 3 days before a closing and the banks gets overwhelmed or an appraisal can't be done or something else. Another aspect is where mortgage brokers are promising the sun, the moon, the stars, but then don't deliver, which happens ridiculously frequently. And in these instances, it used to be the case that that would never be sued for because you'd just get a slightly higher rate and then it wouldn't be worth your time. But now when they're promising the sun, the moon, the stars, they often cannot arrange financing. And then there's the ever typical, oh yeah, I can do this for you. 3 days before, oops, not coming through, but my buddy who is a private mortgage fund lender will lend you funds privately at a much higher rate with 2% lender fees and broker fees and everything else. And I see that all the time. And I'm just amazed that this industry goes forward unpunished by the courts largely. I'm not saying it doesn't happen, but I see many, many more realtors who end up before RICO and end up before the courts, as opposed to mortgage brokers who, in my mind, in my professional experience, usually act with greater impunity.
Well, listen, as professionals, there's no lower duty on a mortgage agent than mortgage broker than there is on an agent. So I can't answer why lawyers aren't doing that. And in fact, you know, if it's if the default falls on the mortgage broker, then the agent, may not have any liability in a situation like that. They can say that, they relied on somebody else to do what needed to be done. So it doesn't make a lot of sense, Mark, truthfully, but yeah.
I agree. I don't understand it because again, I'm of the same opinion as you. They're insured individuals. They're taking on the liability of professional negligence, and yet lawyers don't seem to claim all that often against mortgage brokers. And it's interesting. There's a lot of comments on this, like the CBC investigation. It's interesting because if you speak to some of the large players in the mortgage brokerage field, they believe that between 4 to 6% of Canadian mortgages that have been entered into in the Vancouver and Toronto areas, not Canada, Vancouver and Toronto areas, are about 4 to 6% fraudulent. But again, CBC that just did a huge expose on this didn't come up with a single court case. I know because I was used as the background research for the CBC documentary. And I asked them, I said, do you have any court case on this? They said, no, we're just doing our private investigative research. We weren't able to find much. I don't get it. I'm sorry, if you don't get it either, it's not a fair question because, I don't really have a solution either, but I just figured I'd ask.
I think if I can throw something in there, the person who would be suing the mortgage broker would be the buyer.
Correct.
And the buyer is going to be busy being sued by the seller for not closing. So
but that's exactly right, Sandy. That's the reason why, if they're being sued for hundreds of thousands of dollars, then they have to lawyer up. A lawyer would then look to see who they could cross party. That's the natural, that's the reason I don't get it. I don't get it because the buyer is going to be in a position where they're under the vice grip. They're going to be looking for anyone else to pass the buck. There is someone there to pass the buck. Why is no one actually engaging in that process?
It's the procedure of the third party claims that we talked about before, where, you might be liable under a contract, but if the default was caused by somebody else, then you can try and flow through the damages to that person. So yeah, I would think that in that circumstance, a third party claim should be brought against the mortgage broker, where if the financing condition caused the contract not to go forward.
Maybe I can ask another. Does anyone have any other questions about that? Because I'm going to delve into one other aspect of mortgages. Okay, so Omar is saying something that actually I was going to talk to, and so does Ashley. Omar said mortgage commitments come with subject to clauses which leave the door open and protect them. Ashley wrote, bang on, I've said for years, mortgage brokers and banks need to be held to a higher standard of accountability. As I too have seen this stuff go sideways, often the banks rely on mortgage condition was conditional upon 1, 2, 3. Stephen then writes, I'm just going through the comments and then I'm going to comment. Stephen writes, but the buyer doesn't have a contract to the mortgage broker. Hard to sue without a representation agreement. Mortgage broker is contracted to the lender. And Jag Meat writes, it's fraudulent, buyer will not sue. And if everything else is good, then there's a pre-approval. So first off, Stephen, I don't know that the mortgage broker does not have a contract with the people for whom they are trying to arrange a mortgage. I think it's very clear that they are trying to act in those people's interests. I think the laws of agency apply to them as much as anything else, even if they sign nothing else to the contrary. I think if you sign up with a mortgage broker who's ultimately soliciting work from you and seeking to arrange a mortgage on your behalf, that fiduciary duties flow. Let's let Alan address that one first.
I agree with that. Yeah, I totally agree.
Okay. So I don't think it's about a contract. I think it's about the same fiduciary duties that bind all of us. If you say to someone, I will accept your $5 and try to get you some milk from 7-Eleven, you have an obligation not to run off with that money once it's put in your hand and go to Florida. You have an obligation to go get milk. You are an agent. You are entrusted with certain duties. So I think we can dispense with that one. Having said that, the subject to commitments of the banks, which are very interesting, I want to delve into that because it speaks to mortgage brokerage commitments. You are correct, everyone who's pointed out that mortgages come subject to certain commitments. Most importantly, by the way, They come subject to the property itself being satisfactory to the appraisal standards of the bank that is issuing. So generally, even if you're qualified, not pre-qualified, you go ahead, you provide all your documents. The bank says, yes, on the basis of your TDS and GDS ratios, on the basis of your credit rating, we're ready to extend the following money to you, subject to this property being approved. And then ultimately they send an appraiser and they find that the appraisal value is less or anything else. And they say, well, thank you very much. It was subject to, but it's less, so we're lending you less money. That's how the bank gets out of things. But in my experience, and I think in the experience of most of you, the mortgage broker isn't explaining that dynamic. They're saying, yep, we're going to arrange a deal. And then they say, okay, good news, we have an approval. But at no point are they conditioned to then say to the clients, subject to the appraisal, subject to these qualifications. And thus, when it fails, they basically say, well, what do you want? The bank only extended that. And the answer never then extends to the broker saying, well, why didn't you inform me that this was a possibility? And again, Alan, this goes back to my original question, why are brokers not sued more regularly? But this would be a fact scenario that presents itself over and over and over again. And the question is, does the mortgage broker have that responsibility to ultimately inform when telling people, be happy, you have your approval?
Well, yeah, I think, in a situation like that where the bank turns it down for legitimate reasons, and the mortgage broker didn't inform the client about that, the possibility that that might happen. I don't know, like, I'm wondering how a court is going to deal with causation in that case. Like what did the failure to inform cause, right? Like it caused maybe some, unreasonable expectations on the part of the buyer. But if the bank ultimately didn't approve the transaction for whatever reason, then I think there's an issue there of causation.
Right. Particularly because of when this information. So if the broker is sitting there saying, thank you very much, we've gone ahead and done this, congratulations, it's done. That is different than basically at the beginning of the process saying, I can definitely get this for you, and then failing to get it. So one is simply saying, thank you very much, you're excited, but now there's a failure point, but this was always part of the process and a possibility. Versus at the beginning of the process where mortgage brokers are basically trying to get people to use their service and saying, hey, I can definitely do this for you, and then they fail to do that. That is a reliance issue. Is that a fair distinction?
It is, yeah, I think it is a fair distinction. And, we talked at the beginning about managing expectations as professionals. And I think there's a lot to be said for that, in any kind of relationship.
I agree with that. I actually wanted to talk about that. Managing expectation, the difference between someone who's out, young people who are starting out have the greatest thing in the world. It's the best thing in the world. A, you have time, and B, you have energy. Older professionals don't have either. And what we use, and I'm counting myself in this too, having done this for 20 years, what we use in lieu of that is experience, where when someone says something that's markedly wrong, we have the confidence to basically say, no, you're wrong. No, I'm not going to do that. No, this is an unreasonable expectation. Younger people, by contrast, have all the unlimited energy, unlimited potential, but they don't necessarily have the ability to shoot down stupidity of clients with simple words like that, because they are constantly doubting their own skill sets and their own work, because rightly so, they're at the beginning of their career. But what young people are able to do and get away with much more regularly is, I don't know, let me check and get back to you, which is the standard of competence that exists at that level as well. I'm just throwing that out there because I don't know, let me check and get back to you is not only the standard of competence, but also inspires confidence many times if used properly. Because what it's saying is, I'm telling you what I do know, and what I do know you can rely on, and what I don't know I'll admit to freely. So do keep that in mind. You can't get in trouble with that little caveat and tip early on in your career. I thought that was a very good point by Alan.
And it's a really good point about younger professionals and the dilemmas they face in terms of building up a practice. But where things often go wrong is not being on guard against your client. Taking matters on because you're so anxious to build up your, your portfolio, your reputation, etc. But you do need to, have a sense of where things can go wrong with clients. If clients are asking you to do something, or you sense during a relationship that, there's ethical issues that are arising from the way the client is acting, it can be very difficult, especially for younger professionals to walk away from something like that. But, you will be doing yourself a big favor by walking away from situations and from clients where there are ethical problems or ethical dilemmas that a client is putting you in. It's better to walk away from that, in my view.
Alan, I think that is an ideal point to end today's session on. I'd like to thank you on behalf of our whole group. Above all else, we have a lot of learned professionals, and we have a lot of people who are continually finding that they need professional advice, often subject to professional negligence claims, not because they've necessarily done anything wrong, but just because that's what happens when you're a professional. And knowing that you are out there, knowing that you have given us your time is something that we look to with great value and respect. We appreciate it. And hopefully you will hear from many in our group. Hope not for our sake, but hopefully for your sake, you'll hear from many people in our group, and from our sake, hopefully speaking with you will resolve those issues amicably, such that we can all go on and collectively practice and serve our clients, which is the measure of a professional at the end of the day. So Alan, thank you for being here. Thank you for your attendance. Thank you for your knowledge. And I guess just in general, thank you.
Thank you, Mark. And it was just a pleasure to be here. And thanks for inviting me.
Well, this one was better because there were no Russian hackers that came in the middle and started screaming into the microphone. So we're good. All right, guys. My best to all. Thank you, everyone, for attending.
Have a good day.